Good afternoon, everyone. Thank you. Apologies for the slightly late start. Hopefully, we've got a lot of people who have made it in, and for those who aren't on the who didn't make it in today, we'll send out a link to the recorded session. My name is Michael Redston. I'm a solicitor at Aaron & Partners, along with my colleague Grace Roberts, who is to be a trainee solicitor very soon. We're going to talk to you about national minimum wage, and I've titled it "Why Good Employers Still Get Caught Out." What I'd rather focus on today is what are the little tricks that are catching people out. What are the issues that HMRC are raising that perhaps not all organisations have thought about? Because let's face it, in most cases where there are underpayments found, it's not because of an unscrupulous employer, purposely not paying people enough money, but because of a few small things which may have a serious knock-on. So, our contents, we're going to talk about the obligations under national minimum wage regulations and legislation, how national minimum wage is calculated, although it's sort of a quick fly past on that one, deductions and payments and what their effects have on the national minimum wage calculation, HMRC enforcement and how they approach their notice of underpayment calculations and what we can do about it, the naming and shaming regime, which is of course a reputational concern for many, and sort of top tips, if you like, or really what are the issues that are catching people out. So I think I'll hand you over to Grace to just talk you through the obligations under the legislation.
So good afternoon, everyone. So what are the obligations for employers? Obviously, the first one is to pay at least the national minimum or the national living wage. One thing to note here is that the workers definition here is slightly wider under the Minimum Wage Act compared to the Employment Rights Act, but I won't go into detail on that. But basically, workers refers to workers and employees, everyone except self-employed people, really. The obligations, again, are to not subject their workers to detriment, obviously. Keep adequate records. This is currently been updated, but we'll touch on that later. And also just to make sure that you do cooperate with any investigations by HMRC. So fairly straightforward, but very important.
Absolutely. So how is it calculated? Well, the actual calculation is R over H. Very simple. R is the remuneration, H is the hours of work. In the pay reference periods, just to explain that, make sure everyone knows, the pay reference period under the legislation actually says the pay reference period is a month, or in the case of a worker who's paid wages by reference to a period shorter than a month, that period. So in other words, if you pay them weekly, it's a week. If you pay 2 weekly, it's 2 weeks. That's the pay reference period. The big question really, though, is what is the remuneration and what are the hours? How do you calculate those hours? And so that's sort of where a lot of HMRC focuses on. And the question then, first question is, what is the definition of remuneration? Well, it includes basic salary, as you'd expect. Bonus and commissions are included. Piecework payments, if you're paying by output. And there's also something called an accommodation offset, which I'll tackle a bit later on, but essentially means if you're providing accommodation to employees, there's an offset allowance on that as well. Excuse me. What remuneration doesn't include is benefits in kind, loans, advances, pension payments, redundancy or settlement payments, and I think of most import, overtime or shift premiums. So the overtime itself, the hours worked on overtime, the remuneration they receive would be treated as though it was just basic rate. But if it's time and a half, say the extra half is not going to be included in that calculation for the R figure there, but obviously the hours will be under the H figure. Similarly, tips obviously don't get included at all in that R figure calculation. And then the type of worker, there is some sort of assessment to be done, and HMRC, this is sort of their starting point, if you like. What type of workers do you have? A salaried worker is someone who is paid with reference to an annual salary, but then obviously usually in equal monthly instalments. It could be weekly instalments or whatever, but it needs to be, their contract needs to state that they're paid by reference to an hourly figure, £40,000 per annum or whatever. Timed, now the one thing I'll flag up, and I think I'll talk about it a bit more further on, but with salaried workers, there is one little catch that I think is starting to catch people out, and HMRC are flagging up. If you're intending to pay your salaried worker at the national minimum wage for their age group, then when you calculate that salary, commonly it's often done by reference to weeks, 52 weeks in a year, 7 days in a week, but 52 times 7 is 364. And there's an extra day in the year or 2 days in a leap year. And it's actually catching some employers out where they're sort of setting their annual figure, £18,600 per annum, because they've worked out that for the number of hours that worker or employee is working, that would be the equivalent of the national minimum wage, but they're missing out the fact there's actually potentially an additional working day in not in all years, because in some years it'll fall on the weekend, for example. But there's actually a trick here that HMRC have started picking up employers on. If that's the way, if you've got someone on a salaried contract, but your intention is to pay them at the national minimum wage level, make sure you're accounting for every working day, and you don't base it on 52 times 7, because you are potentially missing a day, and there'll be an underpayment. Right, timed workers, much simpler then in comparison, because it's an hourly rate. So paid at £8.27 per hour. That is the national minimum wage amount. That's last year's amount. Piece worker or output worker, as they're usually called, actually, which is where you're paying them by output, by a specific piece. Again, you've got to make sure what are their hours worked. How do you estimate how long it's going to take them to perform that project, and then is the pay then commensurate with the number of hours that they're going to be working, to make sure you're above that minimum. Okay. Deductions and payments. So, Grace, I think you were going to just start the ball rolling on this, and we might kind of have a bit of a conversation around this, because I think this is one of the key problems.
Absolutely, I think it's something that's more helpful if we use examples. So reducing national minimum wage pay. So what this means is things that will reduce employees or workers' baseline pay. Their remuneration, the R over H figure that Michael mentioned earlier, in terms of how it will be calculated. So first one we've got here is deductions in connection with employment. So this is, for example, you have a new employee, they need a uniform or they need tools or equipment to do their job, and the cost of those are taken out of their pay. So the employer provides them, but the cost is taken out of that pay. That is considered a deduction, and that would reduce the pay figure. Alternatively, the second bullet point here we've got is payments paid by the employee or the worker. So that's a requirement to buy their own uniform or clothing or shoes or tools or equipment, which can catch employers out.
Yeah, this is the big one. I think that I mean, it's probably had quite a lot of press, so hopefully more and more employers and HR professionals are aware of this one. It's slightly different from the deductions. Obviously, this is payments paid by or due, and that doesn't necessarily mean due or paid by the employee to the company, to the employer. If you have a mandatory requirement for your worker to wear, I'm going to say smart black trousers. The reason I bring that one up is Wagamama particularly had a well-publicised argument, if you like, with HMRC over this. Wagamama required their staff to wear smart black trousers. HMRC said, well, not everyone has smart black trousers. You're talking about people who are on national minimum wage, they don't necessarily have an extensive wardrobe. Excuse me. So you're sending them out to buy trousers. Some people might buy £5 trousers from Primark or wherever, and others may be spending more. But you need to account for that whatever they've spent is going to reduce their basic salary, that R figure we talked about. And that became quite a well-publicised issue for Wagamama, but it's come up again and again. I've seen it with black shoes. and other kind of items of uniform or equipment or tools. And so you need to bear in mind that if you're requiring your worker to wear something or to bring something to work or to use something in their work which they have to buy, then what HMRC are likely to do is say that this is an issue. It potentially is going to result in underpayments if they're workers who are near the national minimum wage level, of course. And they usually work out a kind of average nominal amount, so £5 for a pair of trousers. Instead of asking each employer what they paid, they'll get a rough idea from as many employees as they can, and then average it. It's quite often seems to be how they approach it. And then, so there is some scope for negotiating on that, I suppose, if it came up. But ideally, you don't want to be in that position. Yeah, that's payments paid by or due in respect of employee expenditure.
And then we've got deductions and payments for employees' use and the provision of living accommodation, which we will touch on later.
Yeah, so I think we'll talk about those in a bit.
I'll
so
fly past those.
These are the good ones. Did you want to? So these ones don't reduce the R figure for national minimum wage. Were you going to talk about?
Yeah, so the first one we've got here is so workers' conduct. So this is if money is deducted from wages or employees are asked to pay towards something they've done. For example, they break something or steal petty cash and they need to pay it back. But it has to only be for what the worker is contractually liable for. So it has to be ironed out in the employment contract. Clear as day, anything that they are liable for, they will be expected to pay back. If it's not within the contract, then it's not something that you can deduct. But if it is in the contract, then that is an acceptable deduction or payment. Next one is deduction for loans or advance of wages. Michael?
Yeah, I mean, obviously the capital of a loan or an advance, it doesn't reduce national minimum wage pay because, of course, the idea is you get it back. But well, it doesn't. It also doesn't count for their remuneration when they get it into their account. It's not part of their pay. They're going to have to pay it back. Where I think there has been an issue in the past is with admin fees. If you wanted to give an employee an advance, for example, but you needed to administer that over a number of months, you might charge them an admin fee for it. I've successfully debated this point with HMRC, but I have to say, I think the only reason we won is because they changed officer who reviewed it all and perhaps accepted our argument that the admin fee is part of the agreement for a loan or advance of wages, which is, as we say on the screen here, which is specifically what it says under Regulation 12(2)(b). Where it includes these exceptions. So I think arguably you're safe to charge an admin fee for those loans or advanced wages, but I think it is something that hasn't been tested in court yet, and it may depend on the luck of the draw as to how an HMRC compliance officer will treat it if they audit the company. I appreciate that's a bit of a grey area, unfortunately, just not been tested in court to my knowledge. The others, I think, we can just whiz through these with grace.
Yeah,
they're pretty straightforward. Accidental overpayment of wages, purchase of shares, purchase of goods or services from the employer. So that might include if they buy lunch at a team or something, and it's just deducted from their salary instead of payment. And again, it wouldn't affect your remuneration figure for the calculation. So how do HMRC enforce it? Well, the first thing is, what they tend to do is the first thing I say is I think they're casting the net quite widely at the moment. They seem to be targeting nurseries and preschools. We've mentioned that just because we certainly have experience of that. And I think they're looking at smaller private companies, which nurseries will be, as opposed to public bodies, and sort of honestly trying to catch people out a little bit. Or it seems that way. Certainly part of their role, though, is as a regulator. They have a wide remit to do that, and it is quite right, obviously, that national minimum wage is regulated and that employees are protected. That said, the point of this presentation really is some of this is catching people out, not through any not through any bad faith in the way they pay their employees. When they do investigate, what they tend to do is they'll have an initial meeting. They will ask a number of questions about your workforce, about the business, about how they're paid, about the kinds of deductions that you make, for example, as we just discussed. Then they'll usually ask you for more information. They'll probably ask pay slips where they think it's relevant, and any kind of other pay information. If there's things like loans or advances, they may want examples of the loan agreement or the advance agreement. And then they'd assess whether there's any underpayments and provide draft calculations. That's an opportunity then to respond to those calculations before they issue the notice of underpayment, at which point it is like a fixed penalty. It's there, and you can't really argue with it unless you appeal it to the courts, which we'll discuss in a minute. When they do investigate, it is a legal obligation to cooperate with the officer. There are some actual criminal offences related to national minimum wage. Section 31 of the National Minimum Wage Act 98 makes it a criminal offence to refuse or willfully neglect to pay the national minimum wage, which you might expect. In most cases, as I say, that's not what's going on. It's not a willful thing. It's an error. It's a criminal offence to fail to keep the required records, which we'll talk about a little bit. Keeping false records, so obviously falsifying any information, or providing that false record or information to HMRC. It's a criminal offence to intentionally obstruct or delay an enforcement officer. And so, again, that's where I say you really do need to cooperate with them. And similarly, you can't refuse or neglect to answer questions from an enforcement officer or refuse to provide their information. So when we deal with these, when I advise clients on it, or write on their behalf, we will, we give the information that is requested, and we argue over the legal interpretation, generally speaking, of the legislation. And that's where they rely on their own internal manual. It's a manual you can get online. It's on gov.uk. If you Google national minimum wage HMRC manual, I think you find it. It's searchable. It's got contents and everything. And they rely on it very heavily as to how they interpret and how they will treat things like deductions and so on. The issue lies then in whether that manual is correct, and in terms of interpreting the regulations 2015 and the National Minimum Wage Act, or whether there's room for argument, legal argument. I'll come on to some example or one or two examples of when there have been legal challenges. But next is sort of how do they actually calculate their notice of underpayment? That's what that abbreviation NOU means. So once they've given you draft calculations, they will then give you a notice of underpayment that sets out how much they are saying has been underpaid. But it won't just be at the rates that the national minimum wage was at the time of the underpayment, the pay reference period. So say I underpaid my employee £100 in 2019, it's actually going to be more like £105 at today's national minimum wage, because it keeps increasing every year on year. So the underpayment is going to be more, and they work it out essentially. I treat it as arrears. So bear that in mind. It could potentially be more if there's an older underpayment. The rate will have increased. Then there's a financial penalty on top, and this is designed fairly rarely, I think, in employment law, but it's designed to punish an employer. It doesn't. The underpayments, I should say, and the arrears go to the employees who've been underpaid, as you might expect. The financial penalty goes to HMRC and to the coffers. Currently, it's 200%. It was 100% a while ago now, but I think it's so long ago that any investigation that HMRC was starting now would be at the 200% amount. It is halved if it's paid within 14 days. So just to be clear, that's 200% of the total arrears figure. But if you pay it within 14 days, then that would be only 100%. But if one thing to say is, I suppose, if you wanted to appeal their decision, their notice of underpayment to the Employment Appeal Tribunal, then you wouldn't have that opportunity to benefit from that half pay unless your appeal is successful and the notice of underpayment is changed after your appeal. Naming and shaming, Grace.
So if you do get caught by HMRC, as well as having to pay in arrears and pay the hefty penalty that Michael just discussed, your name will also be put on the name and shame list. This list is published on the Gov website. It is literally called the name and shame list. So it's a list of all employers, big and small, that have underpaid national minimum wage. The last one is from August of last year. There's no kind of, it's not posted annually, but so the last one was from August, so maybe we'll have another one soon, who knows. But on this list, 191 companies were listed for underpaying over £2 million. It identifies the number of workers that were underpaid by each employer and the amount that they underpaid by, but it doesn't give any context. It doesn't give any reasonings for what they underpaid for, whether it was these deductions, these payments that we've discussed. There's no context whatsoever, but your name will be on this list. You can't avoid it. That's what happens. Yeah,
there is a very, very limited exception to be put on the list, but it's really actually not. It's not going to be relevant in like 99.999% of the cases. So it's going to be very difficult to talk the way out of it, as well. I'd say. So just to slightly quantify that. But yeah.
But yeah, no, it doesn't matter if you're, a tiny one-man band who employs one employee, or if you're a massive corporation, so like Tesco, Iceland, Pret, loads and loads of big companies are on these lists, and it can cause reputational problems, but.
Yeah, I think the one thing I'd say to that is obviously it's a reputational concern, but at the same time, being published on a list with so many other organisations, to some extent, kind of mitigates that damage. And I think it's not quite as damaging as perhaps one might initially think. The exception to that might be if you have contracts with where you have to put out to tender for local authorities, councils, those kinds of things, where they may have statements that you have to give regarding, fill in forms saying whether you've had any issues with national minimum wage underpayments and so on. That may come to be an issue. Okay. So this is kind of essentially our tips for things to look out for. What is catching employees out?
So always something to be aware of is rate increases. The rate of national minimum wage and national living wage goes up every year around April. And it's also important to remember you don't miss birthday milestones if you employ younger staff, so 18, 21, the rate of pay does go up. So it's just important that you keep on track of birthdays and things like that. So you make sure that you're paying the correct amount to each individual worker.
Absolutely. And then hours worked. Are you clocking the hours that your employees are working, your workers are working? If they're a salaried worker, I mean, in most cases, perhaps with a salaried income, the idea is that you're above the national minimum wage sufficiently to not need to worry too much about the hours that worker's working. But as I said, particularly if you're sort of calculating them to be on the national minimum wage, and then that's how you've worked out your annual figure. Again, you want to make sure, like I said, you want to make sure you're including that 365th or 366th day if it's a leap year. But also, are they working only their contracted hours, or is there an issue there where they're working longer? Sleep-in shifts is another issue that has been in and out of the courts. At the moment, the MENCAT decision essentially means that if someone's on call, then they should be paid at national minimum wage level for that time. If they're on a sleep-in shift, then of course, currently, they don't need to be paid when they're sleeping, but the national minimum wage certainly will apply during any time they spend awake dealing with an issue. What else? Clocking in, I mentioned. When does your worker clock in? When do you start recording their time if they're on a clock? because if they are getting changed, and then if they're arriving at workplace and then getting changed and picking up their equipment and then clocking in, that time when they were getting changed, HMRC will say certainly should have been remunerated for in compliance with national minimum wage regulations. And so really you need your staff to be clocking in before they do anything else, in order to properly account for the hours that they've worked. Similarly, travel, obviously travel to work doesn't count, but traveling in the working day will, from site to site or whatever, which I think most people are aware of, but just to be sure. Remuneration, Grace?
Yeah, we've basically we've covered this one, but just to clarify, so remuneration is kind of all pay, but so things like overtime and shift premiums. So for example, if your employees do overtime and they work a Saturday and they get time and a half on a Saturday, the and a half would not be considered remuneration, so it would just be the standard hourly rate or the standard salary that they receive. Any premiums don't count as remuneration. And tips, so specifically things like hospitality sector, tips do not count within remuneration, so that's something to be aware of for that. Next one is deductions, the big one. So again, we've already kind of touched on these, but it's just super important. So things like uniform, if you ask your employees to wear something specific, even if that isn't a specific uniform, but it's just a specific type of clothing, you have to take account of the costs.
Yeah, I mean, we talk about uniform now. It's not just uniform, it's kind of equipment and tools and things as well, ID badges, anything like that. Something to bear in mind. What else? Mandatory induction training. There is a case, I mentioned that there was some, HMRC and Marketing Limited. And Marketing they had a clause in their employment contract, which is quite common, I think, to recoup the costs of providing training to an employee if they leave within the first year, or a proportion of the costs at least. So a deduction from wages clause. But they were deducting for mandatory induction training, which was part of what they needed to do to do the job. That is for the employer's own use and benefits, which you'll recall we mentioned much earlier as being something which a deduction which would affect the remuneration figure. So mandatory induction training and Marketing were unsuccessful on that point, and the tribunals agreed, the Employment Appeal Tribunal agreed that would affect the base salary rate for those employees when it was used. The Ant Marketing case, though, is also an authority in relation to accommodations. When we get to that, I'll bring it up. I'll talk about accommodation in a minute.
Deductions again. So something that was in the news, not actually that recently, but it is quite a big one that has caught people out. So this is Iceland were caught by HMRC for their Christmas savings scheme. They were fined £48 million. And basically they had this scheme whereby staff would pay in some of their wages into this pot, and they could, it's essentially like a little savings scheme for them without of their wages, and then they could take it out at Christmas. That was the point. Unfortunately, this meant that all their wages fell below the level of national minimum wage, because they weren't receiving that money within like a month of paying it in. So Iceland were found to have been paying them under national minimum wage, and yeah, as I said, they were fined £48 million. Caused quite a drama, but that is something to be aware of, that even though they are receiving the money back, it is considered a deduction.
Losses to the company. So we touched on this already to an extent. This is where you have a contractual right to make a deduction from the employee's wages for something that they owe to the company, essentially. That's allowed. It won't affect the remuneration figure, but you will want to make sure that you've got a contractual term in there that is clearly spelling it out. that kind of deduction can be made. Firstly, because otherwise it would be essentially a breach of contract, and you have an unlawful deduction from wages claim and all sorts, or a breach of contract claim. But also because HMRC would say you're not paying the national wage because you weren't contractually entitled to deduct that amount. And we've already talked a bit about training induction as well. I think we've had a question in the chat about that, but perhaps we'll pick up on that at the end. So moving on from deductions to accommodation, this relates to both deductions and payments. I suppose it's something that isn't going to come up very often. That said, I've had it certainly twice in the last few years come up. If an employer is providing accommodation to its employees, it can charge rent, of course, but there is an offset amount above which, if you're paying charging rent more than that, then it will again reduce the remuneration figure for national wage calculations. What that means is that if you don't want to affect your, or run the risk of you've got an employee on national wage and you're providing accommodation to an employee, then you're not charging them more than what is honestly a very low figure. I think it went up recently, and I have to admit, I think it's about £12 a day. It used to be £7. So it really is a very low figure of rent that wouldn't affect the national minimum wage calculation. Where it's come up with me more recently is a finer point, if you like, but where a director or owner or officer of the employer company also is the landlord, and the accommodation you wouldn't think is provided by the employer. It's not like we're going to provide you a job and a place to live, but oh, you've got this job. Oh, and also I happen to be the landlord of this property. Do you want to stay here? Or the employer approaches the property. HMRC will say that the employer is providing the accommodation there, but the commonality of ownership between the employer company and the landlord company or entity or whatever it is, individual, if it's they've got a director that's the same person, then they say that the employer is providing the accommodation. This is what it says in their internal manual. Interestingly, they had an earlier version of their internal manual written by BEIS, I think about 4 years ago now, which actually had a distinction and said employer may be providing accommodation if X, Y, Z, and one of those was this commonality of ownership issues. So, like I said, probably not likely to come up very often, but it is something I am still debating with HMRC, and that ANT marketing case that I mentioned is authority to say that HMRC are wrong about this. And I suppose my point is, whilst I'm still arguing with them about it, they aren't always correct on their interpretation of the legislation. I have no doubts that they're coming to a good faith and intending to fulfil their role as regulator. But after all, what underpins it is the legislation. The National Minimum Wages Act 1938 and the regulations 2015. That's what underpins it. And how you interpret that really is ultimately going to be down to the judge if necessary. And that's where an employment appeal tribunal has found in ANT marketing's favour that A, HMRC do rely too heavily on this internal guidance without looking at the legislation, and B, that that this commonality of ownership doesn't necessarily mean that the employer is providing accommodation just because the landlord happens to also be a director or owner of the employer company. Okay, and then record keeping requirements. Grace, you were just going to say.
Yeah, so this is a relatively easy one. It does catch employers out though. So in April last year, the rules changed, so you are now required to keep records for national minimum wage for 6 years. So it changed from 3 to 6. So that's just something to be aware of, kind of going forward if you're not already aware.
So what can you do? HMRC come and audit you. Will they negotiate? Well, they won't have a without prejudice meeting with you. They say they can't do that. They're a public body and they're regulated. So they won't have what we would call a without prejudice meeting. They will meet and talk. They just won't want to do it off the record, as it were. but and you can negotiate them with them to an extent. Before a notice of underpayment is issued, you may want to argue with them on the legal points. I brought up the accommodation, for example, and I mentioned admin fees on loans and advances, where I did manage to persuade them to change their mind on that particular point. But what they won't do is just negotiate on a figure. They won't say there is £40,000 worth of underpayment, and you can go, well, we'll pay you 20. Is that all right? And we'll sort of settle it. That's not going to happen. What you might be able to do is persuade them that they should focus on one area and not another. So they may say, we're going to say there's an underpayment of whatever it was, 48 million that Iceland got for the savings scheme, or was it? Yeah, that was it. But we'll ignore the fact that you're also asking them to wear black trousers, and we won't put that in the notice of underpayment. There is some scope to partition off, I suppose, and have that kind of argument. That's all before the notice of underpayment is issued. Once they've issued that, your only real recourse is the Employment Appeal Tribunal to appeal the decision. The issue there, I suppose, is the cost-benefit analysis. If you're, what's it going to cost to appeal? Is how much is the notice of underpayment and the financial penalties? Is it worth it? But also, if if you're appealing on one point, but there are other underpayments which you accept, you're not really going to win on, then you're going to get a notice of underpayment in any event, but the Appeal Tribunal might just reduce it down. So you get reissued with a new notice of underpayment. You'd still have to pay that, and you'd still be put on the the naming and shaming list. And so again, I suppose the question is, going into an appeal, is what are you after? If it's going to drastically reduce the figure, maybe it's worth it. If it's not, or maybe you're better off seeing if you can cut a deal beforehand, like I say. But I think primarily, and I think quite correctly, the main piece of advice is get it right first. As we've shown, that's not always as easy as it seems. If you've got any doubts, obviously please do come to us, and we can try and advise you on things. But ultimately, if you've got good records, if you're making sure that you're paying above national minimum wage, then an audit from HMRC would be no issue at all. And they are, after all, as I said to you, fulfilling a much needed role to police this important legislation to protect employees' rights. And there we have it. Do we have any questions? I think there's been a few in the chat.
We do. We've had a fair few in the chat. Right, I'll read out this one first. So if an employee travels for work and is paid for mileage based on statutory rate, the statutory amount doesn't cover the full cost of travel due to the increase in petrol, and the employee is now going to be out of pocket. Does this factor into minimum wage?
Sorry, I can't see that on the chat actually. Could you just read that again?
Yeah. So if an employee travels for work and is paid for their mileage based on the statutory rate,
yes,
but that amount obviously doesn't cover the full cost of travel due to increase in petrol or other things, the employee will then be out of pocket. Yeah. So would this factor into minimum wage?
That's a good question. It's the kind of thing where I'll be honest, I need to go and check what the statutory rates are. But the overriding principle is an employee should not be out of pocket. If I go back to remuneration and what does and doesn't count, and what deductions do or don't, anytime there's a payment for the employer's use or benefit, so the payment of that petrol at that time is for the employer's use of benefit, for example, then it needs to be reimbursed, and expenses in general anyway will need to be reimbursed correctly. So I can't say for certain in that particular scenario, but the general overriding principle is, of course, to make sure that employees aren't out of pocket, and if it's an expense that they've incurred for work, then it will be treated as reducing their remuneration. So you might need to check whether your mileage scheme is in line with recouping and paying them enough, especially now prices are skyrocketing for fuel. So I hope that's something of an answer.
Okay, so the first one on here then we've got is about paying back for training. If they leave, does it reduce, or is it only if it's in the contract?
Yeah, we did.
touched on this.
Yeah, we did cover that. So hopefully, Susanna, I think you had your answer there. But yeah, yeah, if they leave after a period, the answer to that is it depends if it's mandatory training. If again, this it's regulation. I think it's 13. No, sorry, it's 12.1. Regulation 12.1 of regulations 2015, national minimum wage regulations. Is this idea that any deduction or payment for the employer's use or benefit, and it's very much used by HMRC as a bit of a catch-all. And so if it's training that they need to do the job, that's for the employer's benefit. Sure, it's for the employee's benefit as well because it upskills them. But if it's something they need to do for the job, then you need to be very careful about whether that could potentially reduce national minimum wage. If it's optional training or external training or something that's not necessary for the job, then you might be in a better scenario. That's that one. Then
we've got DBS checks. Obviously that falls under the same category.
Yeah, I think that's right. I'm pretty sure there's some rules on that more specifically as well, DBS checks. But again, it definitely is going to fall under. I have discussed that with a client before. It definitely does fall under being the employer's use and benefit. DBS checks, I believe as well. It's not like you carry them with you to another employer necessarily. You have to have a new one done with each employer anyway. So again, it's for the employer's use and benefit. And I think again, normally the employer has to, otherwise the one. Salary sacrifice. Oh, and then another question where an employee goes on a course and is required to pay the cost back. Okay, so we have covered that. I've had that question a couple of times. Obviously, weighing on people's minds. Salary sacrifice is, again, it's one of those where you need to essentially treat it as though make sure that you're still paying. So the problem with salary sacrifice is the concept is that if you're paying £20 an hour when they're doing a salary sacrifice, then actually their salary becomes £19 an hour contractually, but that £1 is going into a cycle to work scheme or a pension or whatever. Unfortunately, I believe that is treated as so the calculation of the remuneration figure would use that £19 an hour figure. So it is something, again, if you're doing salary sacrifice for someone who's on national minimum wage, then that's where you need to be looking very closely at what you're paying. But I think it's something to get more advice on if you're running those kinds of salary sacrifice schemes with employers who have that kind of low level pay. What was the next question? Can you see that, Craig?
So we've got one from Claire here. So if it's specified in the contract and contractual sick pay entitlement applies for following a year's service, then deductions whilst off sick are okay.
Yeah, I'm not sure I quite follow that question, to be honest, Claire. I mean, contractual sick pay is obviously what you're paying the employee if you're paying them more than statutory sick pay. So then I'm not sure where deductions come into that. But I think it's saying if they take more, I don't know, I'm not sure how that would work. I'm not sure whether there's a deduction there because I think you just stop paying. Oh, are you there, Claire?
Yes, sorry. If they're salaried, for example, and they've taken a week off sick during a month, then we technically not be paying them 1 week. But if they're not there, I presume that's okay. Oh
yeah, no, that's fine. Yes, no, so essentially that the remuneration is at sick pay levels. That doesn't affect the remuneration calculation. Sorry, yeah, so you mean it's not a deduction. Obviously, it's not treated as a deduction. It's a different thing.
Okay.
The remuneration would be paid in commensurate with sick pay levels. It's different because they're not working, so it's not hours worked. Remember that
okay
thing. The H hours worked. So actually, it's not relevant.
Okay, thank you.
I think that's all the questions we've had in the chat. We've already had Claire bravely come on the microphone. Are there any questions? Anyone else got any questions? tell you what, if I stop sharing, we'll see a few more people. If anyone wants to know. I think that might be it, but hopefully I've answered quite a few questions there. We've gone through it all in quite a lot of detail. And in less than an hour. So I think that's perfect timing. So thank you very much, everyone. As I said, if you have any questions or if you have any issues with this kind of thing, please do get in touch with us. Whether that's just to check, whether you're complying with obligations, or whether HMRC are actually speaking to you. Grace or I or someone on the team would be absolutely happy to advise and support you. Okay.
Michael, before we go, we've had one more question.
Oh, go on then.
Is there an implication for directors if they're found to pay under minimum wage?
Yes.
Liability?
Yeah. I did say it's a criminal offence. That also will apply to directors if they're doing it. It depends. I mean, what I'm talking about is if they're doing it on purpose, basically. If there's, I forget the exact wording now, but it's sort of deliberately and can't think of the exact wording, but essentially if unscrupulous directors of companies where they are hiring and bringing in people and cramming them in and not paying them enough, then yes, there is definitely an implication for directors. More generally than not usually, there would be where we're just talking about like a uniform deduction or something, then more usually it would be something that would be an issue. Okay. Brilliant. Thank you all very much.